Welcome back. Now, the South African Revenue Service welcomed a court order suspending the proposed 0.5 percentage point VAT increase. The Western Cape High Court has set aside Parliament's approval of the fiscal framework. SARS Commissioner Edward Kieswetter says the ruling brings much needed clarity for VAT administration and spares businesses and consumers from disruption. He joins us now live. A very good afternoon to you, Commissioner. You have welcomed this decision. Please help us just make sense of it all.
Good afternoon. And yes, we welcome it because for some time now, there has been a lot of public debate and a lot of deliberations in parallel with the minister's announcement that have created a certain level of uncertainty. And so the court order that was issued last night arising from the settlement agreement between the parties brings certainty. And what that now means is there is a legal basis that is beyond any dispute that all parties can agree to, because that's the strength of a court, an order of the court, which now means that on the 1st of May, the VAT rate will be 15%. Leading up to that, of course, SARS had, as it would normally do, act on an announcement by the Minister of Finance, as it is law, that the rate would increase to 15.5%. Taking our guidance from that, we then prepared our systems to administer VAT at a higher rate, and we engaged with all of our taxpayers and traders and vendors and asked them to invest in their systems to make the adjustment. Now, clearly, the minister then reversed that decision last week and announced that a new rates bill would be submitted to Parliament for consideration and approval, and that bill would be retrospective as from the 1st of May. The effect of the bill would have meant that the rate would retain at 15% and not be increased. But there were some questions around the validity of the rates bill and the retrospectiveness thereof. And so what the court ruling does, it puts it beyond any doubt. And so we are pleased that that certainty has now come about. It does, however, imply some practical challenges for many businesses who have invested, like SARS, to make sure that our systems were ready to administer VAT at a rate of 15.5%. All of that work now has to be reversed. And our concern was, given the short time frame between yesterday as well as the 1st of May, which is 2 days from now, whether in fact businesses would be ready. So we have counseled businesses to reverse their systems so that 15% is valid, therefore no change. Secondly, we have cautioned consumers that when they transact on the 1st of May, they must pay additional attention to at what rate a business have charged VAT, and in instances where a business may not have reversed their systems and consumers are charged at 15.5%, they must seek to fix that at the point of sale. And for us, that's very important. And here and there, because of the broad and wide practical implications, we won't be surprised if there's a few balls that will be dropped between now and between the 1st of May and probably a few days thereafter. But we are ready to administer the new law as was confirmed by the court yesterday.
Yeah, and I think for many consumers as well, Commissioner, those balls being dropped is the biggest fear that they have as well, because of course some also received letters from financial service providers, from different companies as well, different service providers, and there obviously is a trust deficit amongst, businesses and consumers as well. And you're saying that those who do note a change in their billing on the 1st of May should rectify that at the point of order, the point of contact. What happens in instances where it's an online transaction, for instance? Are there mechanisms in place that consumers can go to lodge grievances with different businesses that may drop the ball?
Well, so from a business perspective, clearly consumers can engage directly with the business, and if they are not, they don't receive a favorable response, they can go to the various ombuds if they are regulated businesses, like insurance companies and financial services companies are regulated, and there are ombud offices for that. They can go to the Consumer Goods Council. And so they can engage with the regulatory and other agencies that looks at fair treatment towards consumers. But our request to consumers is just to be vigilant, to be aware that it is unlawful for any business to impute a 15.5% VAT in the price that and that consumers must seek to fix it at the point of sale. In the case of an online business, I would be surprised if some of those online businesses would not be able to reverse the decision. It would be highly likely that they will be ready to administer it from the 1st of May. Many of the large corporates and retailers have come to us and said they will be ready, but we've also had a number of calls where businesses, I think conservatively, are expressing their concern. From our side, from a tax perspective, we will increase our level of vigilance. You will know from our previous announcements that we have a very sophisticated AI risk detection mechanism whereby every VAT return that is submitted, and we have about 4.5 million VAT returns per year, that we select typically 10% of that for additional verification as it is alerted by our AI sophisticated modeling. What we will do over the next few weeks is we'll increase our level of vigilance and do a lot more verification of VAT returns to make sure that there is no abuse, either wittingly or unwittingly, by businesses that then compromises consumers.
Yeah. You know, we find ourselves in uncharted territory now with lots of things that are happening that are unprecedented as well, learning as we're going. You made mention that, of course, systems were prepared within SARS and, of course, businesses as well. And I want to talk about the practicality of that and what the practical and legal impact of the court's ruling is on empowering provisions of Section 7.4 of the VAT Act. In terms of SARS authority, when it comes to your role in implementing those VAT changes?
Well, I mean, so the court order yesterday makes it unequivocal that the only permissible rate to charge is a 15% VAT. So businesses, for whatever reason, charge anything differently will be in contravention of the law. And would have to deal with the legal consequences thereof, but also the tax consequences thereof. So, for example, a business cannot now expect, if it paid 15.5% on its input VAT, that SARS would allow them to claim 15.5% on a VAT refund. We will impose the VAT rate as it is legislated. And so businesses must be vigilant to not trip over themselves and be in breach of the law, and in particular not of the tax legislation. SARS will understandably, given the unique challenges and this complex transition, we will engage with businesses and try and understand what their level of difficulty was, and obviously try and be more facilitative than punitive in those instances. But the bottom line is, if a business charges 15.5% on the 1st of May, they will be in breach of the law.
In terms of that shortfall that the finance minister believes that there'll be, I think, about 75 billion rand shortfall in the medium term, should this 0.5 percentage point VAT increase not be implemented, which it won't be, are there other mechanisms, other avenues that you believe that can be taxed or receive that kind of money?
Also, as Parliament directed, the minister will have to table a new budget. And as we stand, we do not have a budget for the current financial year. which means by default the status quo remains, and until a new budget is tabled and accepted by Parliament, nothing changes. SARS obviously continues to administer the laws and collect the taxes that are due based on the current tax laws and the current tax rates. In considering a new budget, the minister will have to look at closing the gap between expenditure and revenue. The minister has already indicated that it is untenable to just increase the level of debt because our debt service cost we can't at the moment, in the current budget, the debt service cost proposed is about 22 cents, 22%. So we can't spend 22 cents on debt, and there's a limit to that, which means you can only close the gap by increasing taxes, by reducing expenditure on the part of government. And what we have added into the fray is to improve the revenue efficiency so that we can collect revenues that are already due to the fiscus. In this regard, we have proposed, and the minister has responded, by giving us an additional amount to focus on outstanding debt that is already due to the fiscus. And we have started to implement that from the 1st of April. That's the short term. Over the medium term, it is about the modernization of the administrative platform using digitalization and AI to improve the efficiency of collection, but also help us deal with these scourges that we have to deal with, in particular, the proliferation of cross-border tax and financial crime, other forms of abuse, either aggressive and evasive tax practices by large businesses or wealthy people, and then a huge focus on the informal economy to ensure that they are brought into the net. So it's not a one-trick pony. It is about looking widely at the entire system and finding ways to strengthen the fiscal integrity by bringing the revenue that can be collected closer to the expenditure that is required.
Commissioner, thank you so much for sharing your time with us this afternoon. Really appreciate your insights on this as well. That was, of course, Commissioner of SARS, Edward Kieswetter.